Or good afternoon. I'm David Laurie. I'm a consultant with the Brattle Group, and I'm pleased to be moderating this afternoon's panel on litigation funding. This is the first episode of a two-part series, and the second episode is scheduled for May 16th. You can read more about Financial Poise and Daily DAC, who are presenting this webinar on slides 48 and 44 of your presentation. Before we dig in, I'd like to thank our sponsors, Mood, which is an online cannabis dispensary, Type to Learn, a digital learning solutions provider, and Max Asset, an online provider of asset sale and auction solutions. You can read about them on slides 3 and 4 and 46 and 47. Just to set the table a little bit and to provide a headline. So litigation and sort of disputes and resolution in the courts has become very expensive. Costs have increased. There's an increasing burden on litigants. And litigation finance is becoming a growing tool to help participants sort of manage these costs while they go through a protracted process. And so to give you some statistics, this is from one of our panelists, Andy at Statera, citing actually one of our other panelists, Connor at Burford. 89% of firm lawyers and 65% of in-house lawyers use litigation finance. This is a 105% increase over past 3 years. 87% of firm lawyers and 70% of in-house lawyers say litigation finance is growing and increasingly important. In 2019, almost $2.5 billion was committed to finance civil litigation. So to discuss today's topics, we've assembled a great panel. We have Andy Waltman from Statera Capital, which is a litigation finance provider. Connor Murphy of Burford Capital, another litigation finance provider. Jeremy Weitzman, who's a business and finance attorney at Much Shellist. He advises clients on litigation financing matters. And Paul Haskell, a business and finance attorney at Crowell & Mooring, who also advises clients on litigation financing matters and distressed debt and claims trading. You can read their bios in the back of the deck on slides 38 and 43, or through 43. And most importantly, I guess a brief disclaimer, this is an educational discussion. You are not our clients and we are not your lawyers. So this is sort of to provide you a background and context and information to ask questions and consult with your lawyers on next steps. So with that, let's begin. So Jeremy, why don't you kick us off and give us a high-level view of what is litigation finance or funding?
So let's use an old school metaphor and reference, going back to Popeye, I'll gladly pay you on Friday for a hamburger today, right? Litigation finance is sort of similar. The concept is you have a third party that's unrelated to the litigation who is putting in capital, typically to help fund the litigation. And in return for that, they are promised a return if there is a successful outcome to the litigation. So in other words, you have a unrelated party helping to finance a litigation for an unrelated claim in return for a potential investment. So what we're talking about is it's a type of investment. And it's used by funders for an investment, right? It's used by plaintiffs and law firms to help fund the litigation, and then as a result, there's a potential return from it. So, in other words, it's a third-party financing of a litigation.
Great, thank you. So I will admit that I had perhaps myself had a very simplistic view of litigation financing and funding, and it was basically finding a third party to sort of offload the costs of the case, and as you said, for a return. But understand that, there are broader applications, such as, using litigation finance to monetize a case or for asset recovery services. Connor first, and maybe Andy, you can tell us a little bit more. Are there sort of broader applications that folks should think about in terms of litigation finance?
Yeah, thanks, David. The application, has evolved. I mean, what Jeremy laid out is spot on in terms of, the genesis of a third party, litigation funding arrangement with, a third party capital provider who incidentally invests in the case in a passive manner. That was, how the business started on a single case, and it has evolved over time, including, in the last several years. From a single case binary risk investment from a third party to portfolio financing for a law firm across the entire firm or an entire practice, or for expenses or what have you, which then becomes less of that binary risk and more cross collateralization across a portfolio. And then the evolution from there, really in the last 5 years or so, has been, as you touched on, David, the notion of monetizing claims for commercial claimants that have high dollar values, that, as the nature of litigation suggests, that dollar value won't be realized until some uncertain date in the future. But that's a corporate asset, and if you treat it as such, you can apply corporate finance or litigation funding to that asset and realize some portion of that value today, or in today's dollars. And that's also done on a non-recourse basis. So the claimant who monetizes the asset keeps that monetization regardless of what happens with the underlying investment. And then in more limited circumstances, as you also touched on, David, the notion of a purchase and sale of a litigation asset is sometimes an option for corporate claimants as well.
And I think, David, I think it's worth emphasizing something that Connor said, which is non-recourse, and what that means, and really what distinguishes this type of financing from a more typical loan financing, in that, to the extent that the underlying litigation is unsuccessful, the funder is taking all of that risk. The funder receives nothing. And so, in addition to having the financial ramifications or financial benefits to a party getting funding, there's also a risk allocation, right? There's also mitigating risk of loss, of losing the litigation, which can be quite valuable.
Right. Yeah, and Paul, I'll jump in there if I may, to sort of jump on with that. Even the strongest of cases have risk of loss. And so if you're a small company with a single piece of litigation, or a corporate legal department that has several pieces of litigation, even if you have a very strong claim, there's always risk of loss, as I would think most attendees of this case knows. And so effectively it's shifting the risk onto a third party that's better able to bear that risk by our creating a portfolio of these, where that risk of loss is absorbed in a portfolio. But just going back, if I could, just for 1 second, the sort of the genesis of all of this is that in the commercial litigation world, different from the consumer litigation world in the US, where in the consumer world, contingency fees are prevalent and readily available. In with commercial litigation, it's not the case. And most law firms, certainly most am law firms, are not equipped to take cases on contingency. And these are very expensive cases that take multiple fiscal years, to see through, and often millions of dollars. And so, what you see in the commercial legal services market is just a gross inefficiency, in that those who are able to access, higher priced, often better resourced, or just, more choice lawyers for a case, have an advantage over those that can't. And so it's really, a tool, whether you're a law firm looking to win business, or a litigant looking to bring a strong claim. It's a tool to level the playing field, to create parity between yourself and the other side, and allow a case to be tried on its merits.
Great. I think we're going to come back to some of those topics in a few minutes, but perhaps getting back to the sort of setting the table, if you will, and sort of the who, what, why, where, and how. Paul, why don't you tell us a little bit about who are the key parties, the principal parties in litigation finance, in terms of the.
Thank you, David. Yeah, so the key players in any transaction are always going to be the three. So it's going to be the litigant, it's going to be the law firm or the lawyer, and it's going to be the funder. And I'll talk about each one of those in turn to set the table. I will say as an aside that insurance companies are perhaps becoming the fourth leg of that stool. But to talk about the first three. So to set the table for the litigants, a couple of distinctions I think are worth drawing. One is there are really two main buckets of litigation funding. One is consumer and one is commercial. And consumer funding is generally going to relate to causes of action, typically affecting individuals, such as personal injury or medical malpractice. And these are often, and this area is often subject to consumer protection laws, state by state, versus commercial finance, commercial litigation funding, which relates to claims impacting businesses and large groups. And so I think our discussion today mainly is going to be focused on the commercial side of things. The second thing it's worth talking about is when we speak of litigants, we're generally talking about plaintiffs. We're generally talking about parties seeking redress. The vast majority of funding is for successful cases to generate cash that can be accessed by a funder. There is always a discussion about defense side cases. There are obvious barriers to funding defense side cases, in that generally if the defense wins an action, they are saving money, they're not generating cash. So there's not ready cash available to pay a funder. But it does happen sometimes as part of a portfolio. You'll see it, or on occasion, if the defense relates to an asset that generates income itself, it may be that the funder is able to take its return based on future income generated by that asset. So that's the litigant. The second major party in this action are the law firms. And typically, these are going to be plaintiff lawyers doing work on contingency and getting funded, getting cash up front to keep the lights on, pay their expenses, pay their employees. I think one of the trends that we alluded to earlier was the last 3 or 4 years, the AmLaw 100 sort of big law firms are increasingly doing more and more plaintiff work and work on contingency. And so the increasingly big law firms are accessing litigation funding. In fact, some of them have publicly announced their relationships with litigation funders. The third bucket are the funders themselves, and these are made up of dedicated funders, such as my co-panelists here. In addition to, you still have some multi-strategy investment funds, hedge funds, or private equity funds, who, as part of their portfolio for their investors, offer investments in litigation. And then finally, I will mention insurance companies quickly. That's really a new big player in this market. They essentially insure the risk of loss, which, as we mentioned earlier, was one of the benefits of litigation finance. But instead of the litigant or the law firm receiving cash, they're paying a premium to the insurance company and insuring some of that risk.
Not really right for today's panel, but I think of insurance. If you have a insurable claim and the insurance company's obligation to defend the claim requires them to pay for defense counsel, that would sort of put them in the shoes of the litigation finance company, and that sort of situation. Putting aside whole issues of coverage, litigation, et cetera, topic for another day. Connor, I noticed, and picking up on something that Paul had talked about, litigants as parties or as clients and law firms as clients. I saw a Burford survey that said corporate clients represented 57% of commitments and law firms received 39% of commitments. Can you just expand a little bit about sort of that distinction and our commitments to corporate clients tied to specific cases, similar with firms? Maybe you could just help explain that distinction.
Sure. It goes back a little bit to what I was speaking of earlier in terms of kind of the evolution of litigation funding. And, as it started, we were talking to law firms and lawyers about their clients and their clients' cases and their clients' financial needs. The evolution has been for funders, particularly like Burford and I'm sure others, are going directly to corporations, talking to their general counsels, talking to their chief financial officers about a particular piece of litigation or a campaign or a basket of litigation, and going directly to those corporates and doing deals, doing these monetizations. So when you look at the amount of money that a funder can put out on a monetization versus fees and expenses on a particular case, the monetizations tend to be higher dollar value. It allows funders to move more money on a single case. And when you look at those percentages that you cite, you see, more money going directly to the corporations versus to fees and expenses because of the monetization aspect. I think it is worth noting as Paul went through the players and, kind of dovetailing with your question, David, structure, and the question we often get for folks that are just simply not used to these arrangements is, how does the relationship work between plaintiff, corporate claimant, and their lawyer vis-a-vis the funder? And the structure is such that we can do a deal directly with the corporate claimant, get the budget from the lawyers and it gets sent to us, but that's what we call a client-side deal, and we contract with the claimant. Or we can do a deal that is contracting directly with the law firm and offloading some of their risk on us. In either case, the relationship between law firm and claimant does not change. Again, we're a passive investor in the litigation, and those two parties carry on as if there was no funding arrangement in place, generally speaking.
So I want to move us along a little bit. One of the questions I think we've generally covered is, why would someone seek or need litigation funding? We've heard that it's a way of sort of managing costs, creating some cash flow, particularly in the contingent litigation context. You can read a little bit more about those issues on slides 12 to 15, 20 to 21, and 23 of the deck. So I want to turn to you, Andy. I read somewhere that, not to pick on Connor's company again, but Burford has looked at more than 12,000 matters, and I would imagine they have funded only a percentage of those. In your role, Andy, can you tell us a little bit about sort of yield, I'll call it, sort of cases you look at versus cases you fund, and what makes a case more attractive than another?
Sure.
And for your reference, audience, this would be slides 14 and 15 and 22.
Sure. Statistically speaking, I think the volume of cases that Burford looks at is probably more substantial than my firm. I think we looked at maybe around 500 single case investment needs last year. But I think across the industry, at least from the data that I've seen published or shared by pure play funders, the selection rate is relatively low. And so I think, folks should come into these conversations, particularly if it's their first, conversation with a funder, with an understanding of one, many of these cases, probably 95% of these cases are passed on, and there's generally a few reasons. And some of those you can overcome, some of those you simply can't. But in our firm, and Statera Capital is a pure play commercial litigation finance firm, meaning that's all we do. But we focus on single case investments, which are different from portfolio, and maybe Connor could share a little more on that. But you know, it's you know, the things that make these cases attractive to us are fairly common sense. I mean, number one, the you know, the gatekeeping item for everything is merit. You know, is the case strong on the merit? Is there a story there? Is there liability that, you know, we can understand very quickly? The second piece of it is, are there damages, you know, that we can calculate at the point we're engaged? Sometimes we come in very early in the conversation, or I'm sorry, in the litigation. Sometimes we come in, you know, sort of more midstream or even closer to trial or even on appeal. Can we calculate the damages? Can we discount those damages down to what we believe is a realistic settlement value of the case? And then, you know, is there cogent evidence? You know, is the case supported by enough evidence to see it through? Who are the lawyers? You know, what's their expertise? Have they done these types of cases before? Who is the defendant? Are they able to pay? You know, funders are you know, not in the business of you know, financing cases that will be a judgment on paper only, that can never be monetized. And so, who is the defendant? Are they able to pay? Are they incentivized to settle? Are they going to behave rationally? You know, the more sophisticated the defendant is and their counsel, the better it is. You know, we're looking for cases that are very strong and will proceed down the path and likely be litigated because there's real value at issue. But at the end of the day, you know, rational parties will make rational decisions and they'll settle that case. To that end, you know, what is the plaintiff's motivation? You know, our counterparty is typically the claimant, not the law firm. What is their motivation? You know, are they focused on recovering damages only? You know, if there's an animus, if there's any sort of, you know, tertiary issues between the litigants, you know, that makes a case less attractive. Who is the judge? What is the forum? What's the duration? Is there a backlog in cases? You know, we have data now where we can look very specifically at judges and understand, you know, how they've handled prior, if it's an antitrust cases and, you know, in their dockets. And so it's a lot of what the litigant should be looking at, but, you know, oftentimes with, you know, as much, if even more, focus on where does this thing ultimately land and can the defendant pay and or settle this case.
So, Connor, are there particular types of cases? I mean, I think of commercial litigation ranging from, you know, a business divorce, M&A litigation, IP disputes. Andy mentioned antitrust. Are there particular subject matters that are more attractive than others, or, you know?
It's a great question. You know, as Andy touched on, you know, a good commercial case is a good commercial case, whatever the underlying you know, subject matter is. Generally speaking, you know, we're interested in, you know, in the soft IP space, copyright, trademark, it gets a little trickier, but generally speaking, you know, the core of our entire business is U.S. commercial litigation. You know, and you kind of ticked off some of them. Antitrust is certainly a you know, a highlight. You know, general contract business towards construction, bankruptcy, et cetera. You know, and then even in and outside of bankruptcy context, there's claims that, you know, we you know, favor over others. We're not, you know, super in the business of, you know, pursuing malpractice claims against accountants and law firms, you know, things of that nature. But generally speaking, as I said, you know, a good commercial claim is a good commercial claim. But just to add on to what Andy said in terms of, and this entire slide we could go days on, but from our purposes and from where we sit, oftentimes the big, aside from merits, the big kicker to prevent a case from getting funding from us or otherwise is simply the economics of the case just don't work. Like, not every case is fundable just because the economics aren't there. Everything checks out, all the things that Andy's looking for, but if the damages relative to the investment ask isn't enough such that, you know, the lawyers get paid, the funders get paid, and there's a meaningful, you know, return for the claimant at the end of the day, we just can't and won't do a deal like that.
And Connor, I just one thing to emphasize, because I do sometimes see cases that look great, but there's a concern that even though there's a great defendant, great cause of action, the remedy might not be cash, right? The remedy might be stock, or it might be a license of IP, and that's really can be worrisome, right, for a funder.
Yeah, or estoppel, cease and desist, that type of thing. There has to be some sort of monetary exchange where we can get our investment back. And like I said, we could go deep on that slide. That's another area where if victory for the claimant is something other than money, that's great. Nothing wrong with that. But if we can't get our money back and entitlement, then that simply doesn't work either. That's a good point, Paul.
Yeah, and if I can jump in just one more real quick on that, I couldn't agree more with Connor, and I'm glad you said it, Connor, because probably more than any other single reason, it's the economics of an investment that that prevents us from coming in. And what we mean by that is there has to be enough spread between the budget needed, the financing you want to take from Statera or Burford relative to the damages, because at the end of the day, what the funder is trying to do is structure an investment where the claimant is always in the majority of the proceeds. So if you settle this thing for 50 cents on the dollar for, your actual damages, we still want you to have the majority of the proceeds, and our capital is expensive. There's no doubt about that. And so if you come to us and you say, I'm with, not to pick on Skadden, but Skadden, and Skadden's got a $5 million budget for this $10 million contract claim, we're going to tell you, your case is great, but unfortunately we can't finance it with that budget. That doesn't always mean that your case is not financeable. And I'm not trying to steer business from Skadden or any other law firm, but oftentimes there are lawyers, the Skadden spin out, who is able to take that case for $500,000 or $1 million or share some of the upside. And then all of a sudden that case does become fundable. So economics are a huge challenge with these cases. But that is solvable.
Yeah, and the corollary, as you touched on, like, even though your case isn't fundable or won't get funded, doesn't mean you can and shouldn't bring that case with a lawyer that can make it happen, as you suggest, Andy. And that's always the conversation we have.
So, Andy, you mentioned that capital is expensive. And I come from a PE background where sort of generically we underwrote deals for 3x cash on cash return and a 30% IRR. And I think about contingency litigation cases where often the contingent fee could be 33% or 40%. Without getting into the secret sauce, can you give us just a very high level perspective of what the cost is?
Sure. Yeah, I think most in the industry, particularly in the single cases, and this is different from portfolios, whether that's with a law firm or corporate legal department, single cases are typically priced in the market as a multiple on deployed capital. And so what that means is if you came to us and you said, I have a $10 million contract claim, I need $1 million if this thing goes all the way through trial, we will commit that $1 million to you. If you only take $500,000 of it and you settle that case, and I'm not, I can't speak for everyone in the industry, I've heard otherwise, but we would only charge you on the $500,000 you use. But it's typically priced as a multiple on what you use. And so, if you use $500,000 and the multiple starts around a 2, you'd owe us $1 million and you'd walk away with $9 million, and David, to your example, if you were able to recover $10 million and you're able to do it, for even $1 million and it's a 2x, it's $2 million is the cost of your capital on that, versus giving $4 million and a 40% contingency to a law firm. So the multiple, often for most, I think starts, around a 2 plus or minus, steps up over time. It's not, uncommon to see the multiple step up every 6 months, a half a turn, or, every year a turn, a full, from a 2 to a 3. Internally, we price these things by IRR, but, as far as, I understand the market, most translated that into a multiple when speaking with counterparties.
But on this point, I mean, it's also important to understand that it's all a part of the risk. There are some funders that are willing to take on riskier cases, in which case, the number of turns is going to be higher, almost inevitably. The other thing is, as Andy started going into, some of this depends on how long the money's outstanding. both from in terms of an IRR and a risk standpoint. A case that's going to settle quickly, there's going to be less risk, and some of this depends on when the funding is sought. Is it pre-case? Is it after, motion to dismiss? Is it pre or post summary judgment? So some of those just general time aspects, which always goes into the risk analysis on, one, is it fundable? And two, what is going to be required in terms of a return from a funder?
So, Jeremy, thanks for jumping in, because you are my next victim. And we do have a second episode that's going to get deeper into the process of litigation finance. But I think it's important for this episode to go over some of the high level issues. Against my background is in distress and restructuring, and we have a phrase which is that denial is not a river in Egypt. And by that, I mean, people often wait too long before seeking help from advisors, financiers, financing parties, etc. Analogizing that to this situation, Jeremy, you touched on it, I think, just in your comments a moment ago, but when is the opportune time for a party, litigant, or a law firm to seek litigation funding? Is it, pre-filing, post-filing, 6 months in, going to appeal?
So, representing funders, my answer is always. But no, that's selfish. No, it really depends on what the need is. One of the biggest aspects that we haven't touched on yet is, what other benefits funders bring besides the cash, right? So obviously the obvious answer to your question is when they think they need the cash, right? If it's a David and Goliath, they need it right away. They need it before it starts. Maybe it's if it's a corporate case and it's a corporate legal department, maybe it's, a little bit in when the CFO says, boy, we're spending a lot of money here trying to finance this litigation. Maybe this is the time. Ideally, the timing is, pre-case from my perspective. And the reason for that is, in addition to the cash, funders typically provide consulting assistance with the case. Meaning you're talking to experts in the areas, right, that see these types of cases all day long, evaluate these types of cases, the risk, the rewards, all day long. So if nothing else, obviously, you're going to go with a reputable law firm to help you in the case. But most folks in this space either are directly former, big firm attorneys in a lot of cases, or they have resources of big firm attorneys. So you may have, a great law firm who has a litigation strategy, looks at it as a plaintiff, tells you, you got a winner here. And you know what, if you've gone to 2, 3, 4, 10 funders and they go, no, we don't see it, you may want to reevaluate that. A lot of times, and I think we'll get into this later, there's a doctrine called the common interest doctrine that allows funders in a lot of cases to kind of sit sidecar with you and your attorneys. Not that they make decisions, because they can't do that, but to have a interested party that has a voice in what they think about where your case is at and where it should go and what the risks are and what the rewards can be. So in my opinion, if you're going to go this funding route, better to have that extra partner, if you will, earlier in the game rather than later. Because it'll give you a gut check on what you think your case is and what your attorney thinks your case is, as well as just another probably really smart person that can help you with strategy and everything else.
Great. Paul, do you have anything you'd like to add?
Yeah, absolutely. So I see it in my own firm. I see it come up in two scenarios. One is the fatigue scenario, where your firm, one of your partners has been running a case and it's going longer than anticipated, and the CFO of your firm starts saying, what's going on with this? Can we, maybe we're having a bad year, maybe we can bring in some revenue this year instead of waiting. So there's the fatigue. So there's that scenario. The other scenario is there when a litigation partner will come to us with a case and they want to pursue a case, and the firm says, we're happy to have you pursue it, but it doesn't, we're not going to agree for you to pursue it on full contingency. There has to be some partnering with a funder to make it work, because the expenses are going to be too great, and it's not a burden of risk or expense that the firm wants to bear long term. Great.
And then Andy or Connor, is there from your perspective, is there a too early, too late problem? You know, someone comes to you and says, not develop it a little more and then let's revisit it, or this case is way too far along in a process. It's we think the path is kind of clear, so it's just too late. Is that you know, is there a too early, too late distinction?
I think that the bias there would be maybe more toward the too early. Sometimes, you know, folks will come with us, you know, with a funding ask that is just, you know, a cake that's simply not fully baked yet. And not that it has to be fully baked, but like conceptually, they don't have counsel in place yet. They have no idea what their budget litigation, you know, the funding ask is. There's no, you know, draft complaint, no really anything, and it's hard for any funder to kind of conceptualize what they're looking for. And now, you know, we can help in that formulation process and refer counsel and the like, but sometimes it is just too early. We do like to see counsel in place, because that's who, you know, we're also betting on. We'd like to see what counsel is thinking in terms of approach, and you know, we don't need to see a full complaint, but like, you know, what's their budget? How are they getting from, hey, we think we got a case, to, you know, through discovery, through motion practice, you know, through trial to get to some sort of resolution that's favorable. And, you know, sometimes the case is just simply too risky and we don't know enough pre-discovery or pre-motion. And we say, hey, you know, if you survive summary judgment or this MTD, you know, please come back to us. It's interesting enough, but we just want to see you get to that hurdle. And that oftentimes does happen. They'll come back, you know, for a second or third look oftentimes. On the longer side of things, you know, as I think Andy alluded to earlier, you know, sometimes people come post judgment, it's on appeal, you know, what can you do for us? Anytime, you know, during the course of it, oftentimes, as Paul mentioned, fee fatigue, you know, folks will come and say, hey, what can you do for us here? And then and the notion of, you know, backfilling them for any fees that they've paid to date is also an option, and often interesting to claimants who have fee fatigue and didn't want to start paying for it to begin with, let alone, you know, longer than they had anticipated. So it really does, you know, reach the gamut.
Yeah, I would agree with that. I mean, I think we have funded things from, you know, first conversations with, you know, between the claimant and their lawyers. I agree with Connor that, you know, the lawyers need to be engaged. They need to have an idea as to, you know, what their strategy is, what the budget is. You know, our commitment's tied to a budget. And so it has to be developed enough to get there. Some funders out there will tell you that they won't come in, you know, before a motion to dismiss. If you run into that, don't stop there. There's plenty out there, including us, who, you know, aren't afraid to underwrite the risk of a motion to dismiss. But it's really, everything is case specific. You know, we've done everything from pre-complaint to, you know, as Connor said, to, you know, cases on appeal and you know, just waiting for money to come in the door. And again, this all goes to, you know, sort of what are the uses of this capital, and there's so many these days, and you know, this is a very sophisticated, very smart industry, not only with the pedigree of the lawyers who are involved, which is impressive, but also, you know, the finance professionals, the bankers, and so on, who've come in, and so this really has become a solution that, you know, when you go back to sort of the idea that, you know, a legal claim is an asset, and you can extract value on that before it pays at the end of the day. You know, there's lots of things you can do. One point of Connor's, though, just, you know, to be careful of is when somebody comes to us, you know, 2 weeks before trial or before summary judgment ruling and tries to de-risk themselves entirely, that's a big red flag for us. So we're always, you know, keeping a close eye on what's the motivation at whatever stage people come to us.
Great, thanks. So at the risk of dating myself, I can think of old Yellow Pages ads when they'd say, let your fingers do the walking. I think now that's, I guess, the Google machine and letting your fingers do the typing. Um, Paul, can you tell us a little bit about how you obtain litigation financing at the outset? So, and I'm looking sort of at the first bullet on slide 19. Do you there's sort of outbound, inbound calls? How do you start the conversation?
Sure. So excellent question. So the first thing I'll say is that funders are not shy. And if you let Google do the talking or do the walking, you see that they all have good web pages, and they do advertise. From a situation from a lawyer, very often the scenario will be I'll have a firm client that's looking for funding, or I'll have a partner who's looking for funding, wants to take a case on contingency and looking for funding the law firm. But funders are very good about creating relationships with law firms and lawyers. So if you're a plaintiff with a potential case, a very good, excellent source of contacts in the legal finance industry is your lawyer, and they probably have relationships with funders and may be able to guide you. There are brokers out there, so there is also a small industry of professionals who will act as a broker and find financing for you. They do charge a fee for it, so I do always caution my clients who want to use those. But the process, it's work. When I tell my clients, and I tell my partners that it's not simple. It is work, because you are building a relationship. One is it's finding a match, and then two is making sure you have a good relationship with that funder before the two of you come together in a transaction, in a marriage. Because not all funders are the same. I do caution that each funders all have niches, and funders have different appetite for a lot of things. The size of the case, the size of the funding, the type of the case. Is it intellectual property? Is it antitrust? The stage of litigation that it's at. Has the complaint not even been filed yet, or do you have a judgment and it's on appeal? So risk appetite. So funders have different appetites for risk. Some prefer portfolios and only do portfolios of cases, and some will do single cases. And some have a preference for funding a law firm versus funding a plaintiff. So I do caution that it is a process. It is good to speak with several funders. Hopefully your own counsel can guide you and introduce you to the right potential funders.
Great. So I want to jump ahead. I think there are things that I will hopefully come back to if we have time, but I want to jump ahead to some legal issues. And in particular, I'm looking at slides 24 to 28, 17, 29 to 32. And from I guess a transactional perspective, these are probably some terms that people don't use in their everyday parlance: champerty, maintenance, barratry, but they might recognize usury as a term. Jeremy, can you tell us just a little bit about some of these legal issues and how they impact the process?
Sure. So given that we're a little tight on time, I won't walk through maintenances and barriers. Suffice it to say, the first three bullet points there are medieval concepts that were developed to keep feudal lords from financing, basically fighting with one another using proxies, right? So they didn't want people to fund litigation against their rivals. And so all these have to do with, can you fund cases? Are you allowed to take a return on somebody else's action and cause, claim and cause of action? And So for years and years and years, they stuck around the common law. Generally speaking, although not universally, most people have come to realize that those are, kind of outdated concepts, although not entirely. But it's now generally accepted, at least, that's why the industry has been able to grow, that these types of claims are outweighed by the benefits provided to this industry. So for example, if you have your small IP patent holder, and Google has just taken it from them, right? The public policy is that, well, no, you should be able to defend yourself, right? And so how do you do that? And this is a way to be able to do that. So again, medieval concepts still can impact, and there are some rules in some states that these are still valid, but by and large, they're sort of outdated. Usury goes to kind of a interest rate and a rate of return, and generally speaking, these are not deemed to be loans, right? So the concept of having a maximum return doesn't necessarily apply. At least in the context of commercial litigation. Consumer, there's still some restrictions on it. But in the in the commercial space, right? Generally speaking, you don't have limits on rates of return. You have sophisticated parties that can go to counsel, that can make their own business decision, et cetera, et cetera. Fee splitting is a concept that attorneys can't share revenue. Again, these are all kind of technical arguments that I think for purposes of this discussion today, understand these are all out there, valid, and there are methods that have been developed within the litigation financing industry to deal with all these, and so that they're either non-issues or there are ways to structure transactions so that they become largely non-issues.
Right. And then, so now that we've engaged a litigation funder, I would imagine that they require some form of reporting, some information. Maybe they want to participate in reviewing pleadings, or maybe they're completely passive. Paul, can you talk a little bit about privilege issues, work product, and sort of how you interact with the litigation funder?
No, absolutely. So I think, as has been mentioned previously, the whole process starts with a dialogue, and a funder could be an excellent partner to the law firm and or the plaintiff in terms of vetting the case, considering the issues in the case. As has been mentioned, the funders have a great deal of experience often in these types of cases and the issues that may come up. So information sharing is an important issue. There are two types of sharing. One is the conversations between the funder and the law firm, and for the most part, and there's a question about is any of those discussions subject to discovery? And so for the most part, the courts have been pretty consistent in saying that there's a work product exemption for those types of conversations. Privilege is another issue, with whether or not the disclosure of privileged information to the funder could be deemed to be a waiver of that privilege. And again, for the most part, it depends on your jurisdiction. So funders are very careful by creating a common interest, by starting with a non-disclosure agreement and a common interest agreement between the funder and the plaintiff. That information is, for the most part, protected, but great care is taken in ensuring retention of those privileges.
So in our last 10 minutes, I think I'd like to talk a little about war stories, and in the context of talking about war stories or real case considerations, I think it would be helpful, and I'm going to look to Connor and Andy to lead this part of the discussion. Perhaps pick a case of recent interest that had some media issues, and maybe you can talk about the structure, whether you are active or passive, and how sort of a case evolved, and if it went well, went longer, shorter. So Connor, why don't I start with you? If you dig deep into your experience and lead us off with a meaty war story.
Geez, thanks. I mean, war story. I don't know if I would quite coin it that way. There's been no shortage of media coverage on large matters that we've invested in, that have come to light in the press. And I mean, that raises another issue, really, is disclosure about these arrangements, and whether they ought to be disclosed, and if so, when and how. But that's a separate discussion. But I think, as we look at the industry as a whole, as we touched on in the last slide, the war that has been waged was, is this even legal? Can you do it? And I think that war has largely been won, not in every corner of the earth, but generally speaking. But the battles waged along the way have been, largely around disclosure issues. And I would say, those battles are largely lost or on their way to being lost with various legislation and local rules, et cetera. And there's two sides to that coin, whether that's good and what disclosure means. But I say all of that because some of these large investments that we've been involved with have been disclosed for one reason or the other, whether it's in the context of a war story, or that's just was the way the local rule was in the Central District of California. And in our mind, you mentioned, if you look at the Cisco case, for example, I mean, we gave them, that's a large, well-capitalized company that took a monetization on some large claims to the tune of $140 million. Is that a war story and how it unfolded? Yeah, I think you could probably put it in that category. But I think the net has been, somewhat positive in that it shows to the world that this is, real corporate finance for law, and large, well-capitalized corporations are looking at their litigation assets and seeing what they can do with them and how they can unlock their value, and realize a liquidity event today. And as Paul said earlier, it's not just a liquidity event, it's a risk-sharing event as well. So you take the good and the bad on that, but that's just kind of how that one shook out. But I think there's some real positives that came for not only Burford but for the finance industry.
Does your view on disclosure, and by disclosure I take it you mean disclosing to the court that there's a litigation funder in the case? And I would imagine that one of your concerns is that if there's a jury, they might perceive that one way versus the judge, as sitting as the finder of fact, can sort of do with it what he wants.
Yeah, I mean, how relevant is it? Is it relevant? Maybe there's some circumstances that would warrant that it is relevant. I would posit that it's not. But like I said earlier, or I touched on, like, disclosure can mean a lot of different things. You could tell a jury that there's a litigation funding arrangement in place. Okay, what bearing does that have? I don't know. And then, kind of step two would be, well, there's a funding arrangement in place, and identify the funder. Is it Cetera? Is it Burford? Is it somebody else? And we've seen both of those. What I haven't seen is step three, is the terms of the underlying financing arrangement. So which I think you can argue against all day long, and I'm sure Andy has a view on this as well.
Yeah, I would say, well, first off, I'd say we've been fortunate that Connor and Burford are the market leaders, and they get to sort of pave the way through a number of these issues, and we sort of ride in the wake and enjoy the benefits of it. But I mean, if you look at where this industry was, 5-10 years ago in the US versus where it is now, I mean, so many of these issues have sort of been normalized, if you will. I mean, dial back 10 years ago, you know, when you explained what we did, folks would sort of scratch their head and look at you. You know, it's rarely now that, you know, we talk with lawyers who don't understand what litigation finance is, what the value of it is. And the same, you know, as you get into these, you know, these issues of privilege and disclosure and usury and things of that sort, you know, it's, you know, the case law is well developed in most jurisdictions, you know, and it's all very favorable to what we do. I mean, at the end of the day, we are passive third-party investors. We're not controlling litigation. Obviously, as Connor's explaining, you know, these are big, sophisticated transactions, and people are going to poke at them and try to test them. But at the end of the day, you know, everything is financed somehow, and we're just another, you know, tool that either a company or a law firm can use, you know, to effectively litigate cases that should be litigated. And so, you know, you know, I appreciate Burford because one, you know, they're the market leader and they publish a ton. So if you're unfamiliar, you know, go look at their material. They provide a ton of educational information, but they've also, you know, just had to live some of these issues firsthand. I would say, you know, from my perspective, you know, the more thematic than specific war stories, you know, are that, you know, these cases all take longer than anyone ever anticipates. Damages are more challenging than anyone anticipates. Settlement dynamics are more difficult than anyone anticipates. I mean, things are just harder than, you know, you know, when a case starts, and that's not unique to our industry. It's the nature of litigation or any business transaction. And so, you know, being very careful and being very conservative, you know, one, with who you partner with, but two, how they're viewing this transaction, you know, from the very beginning, is just incredibly important, and finding a structure in the transaction that works for all. And this is a three-legged stool. I mean, there's the claimant, who should come away with most of the money. There's the law firm, you know, that wants to have, you know, an engagement that's, you know, if they're taking risk, they should be compensated for that. And they should be more profitable than a standard hourly engagement. And then the funder, who's got a cost of capital as well. And so, you know, you just want to be very careful and you know, think very critically about the path these cases can take and how long it's going to take, and you know, what happens if before you get there. And that's not only on the structuring, but also, you know, on all of these issues in the different jurisdictions. You know, partner with responsible parties, you know, well, I'll leave it at that. But on the disclosure piece, just one snippet on the disclosure piece. You know, I couldn't agree with Connor more. I mean, what's the relevance? And you know, I find it more that folks poke at disclosure not because they're concerned that the judge might be invested in the company, like, you know, you have, you know, disclosure rules to avoid conflicts that way, but it's really just a way to sort of cause cost and distraction by, you know, taking discovery into the funding agreements. And you know, the case law is very well developed that this stuff isn't relevant. It's protected by work product. And so you're not going to get it, but it's a distraction. It takes time. It's a cost. So I have no issue with disclosure, in the sense that I think if a defendant knows that a plaintiff is well financed, you know, the case is going to behave differently and more efficiently. But anyway, I'll stop because I know I went over my time.
So Paul and Jeremy, if you had I'll give you 30 seconds each. What's a takeaway practice pointer that you would like to leave our audience with?
I'm happy to go really quickly. So I'll just say, I think, you know, Andy and Connor mentioned trust and relationship. I think Jeremy and I can paper the documents fantastically. We can think of everything, every contingency, and the funders can create a structure where all parties are economically motivated to behave well. But either as a plaintiff or as a lawyer or as a funder, you have to trust your counterparty. You have to have a relationship with somebody that you feel comfortable with. You have communication and trust, like a marriage.
Jeremy, you got the last word.
Well, I will echo everything my colleagues said. You know, in this, I think it's a fantastic avenue for parties to fund litigation matters, whether they be law firms, whether they be plaintiffs. It is a maturing industry, although not fully matured yet. But it's much more than when Weiss started in the practice. It's a win-win-win, right? You get the potential for cases funded, you minimize risk, you get typically really good people if you partner with the right people, per Paul's points, and it's it certainly beats mortgaging your house and putting the company at risk to engage in a litigation. So I think it's a great tool, and that's really what it is. It's a tool, and it's just really an exciting industry to be a part of. So,
Well, we're up against it. We finished right on time. I'd like to thank Paul, Andy, Jeremy, and Connor. I thought it was a great conversation. I hope the audience appreciated it. Our second episode will dive into greater detail on the process and some of the structures, and encourage you to join us in May for that episode. Thanks for your participation and have a great day. Thanks.